In this video, we would like to discuss the most important doctrine in constitutional law, that is the doctrine of Pith and substance. That very doctrine we derived from Article 246 of the Constitution of India, which gives exclusive lawmaking power to the Parliament of India on the basis of the distribution of powers on lawmaking as provided under Seventh Schedule in three different lists like Union list, State list, and concurrent list. So Parliament has exclusive law-making power or the legislative power. Besides Union list, it has also the exclusive power to make law both on concurrent list, which would override the lawmaking power of a state under state list. So the very doctrine of faith and substance, as explained in no field of constitutional law, is the comparative approach more useful than in regards to the doctrine of faith and substance. This is a doctrine which has come to be established in India and derives its genesis from the approach adopted by the courts, including the Privy Council, in dealing with controversies arising in other federations. Briefly stated, what the doctrine means is this: where the question arises of determining whether a particular law relates to a particular subject mentioned in one list or another, the courts look to the substance of the matter. Thus, if the substance falls within Union list, then the incidental encroachment by the law on the state list does not make it invalid. This principle had come to be established by the Privy Council when it determined appeals from Canada or Australia involving the question of legislative competency of the Federation or the states in those countries. In India, the doctrine came to be established in the pre-independence period under the Government of India Act 1935. The classical example is the Privy Council judgment in the leading case, Prafulla Kumar Mukherjee versus the Bank of Commerce Limited, Khulana, in 1947, as it was a leading case from Madras, the Privy Council holding that a state law dealing with money lending, a state subject, is not invalid merely because incidentally affects promissory notes, which is a part of Union list under entry 46. The doctrine is sometimes expressed in terms of ascertaining the true character of legislation, and it is also emphasized that the name given by the legislature to the legislation in this short title is immaterial, again for applying the doctrine of pith and substance. Regard is to be had to the enactment as a whole, to its main objects, and to the scope and effect of its provision. So, in regards to the constitutional validity of enactment, we'd like to discuss the very important leading case, that is case of Lal, Khemchand and Sons Private Limited versus Union of India in 2015. Supreme Court held that when the enactment is otherwise within the constitutionally permissible limit, the fact that there is a divergence between the objects appended to the bill and the term of the act cannot be a ground for declaring the law unconstitutional. So, in the very leading case, Delhi Cloth and General Mills Company Limited versus Union of India in 1983, the Supreme Court expressed the view that applying the doctrine of pith and substance regard is had to be given to the very enactment as a whole, so to its main objects, and also to the scope and effect of its provisions. And now we'll discuss another important leading case where the same pronouncement was made by the Supreme Court in 2011, and that is Girnar Traders versus State of Maharashtra. And now we'll go to another important leading case, that is B. Vishwanathia and Company versus State of Karnataka in 1991. Supreme Court held that no question of conflict between two lists will arise if the impugned legislation by the application of the doctrine of pith and substance appears to fall exclusively under one list, and the encroachment upon another list is only incidental. And now we'll go to another important ruling in 2003 by the Supreme Court in the leading case, Welfare Association ARP versus Ranjit Gohali, where Supreme Court pronounced that in every case where the legislative competency of a legislature in regard to a particular enactment is challenged with reference to the entries in the various lists, it is necessary to examine the pith and substance of the act and to find out if the matter comes substantially within an item in the list. The express words employed in an entry would necessarily include incidental and ancillary matters so as to make the legislation effective, as it was pronounced by the Supreme Court in this important leading case. B. Vishwanathia and Company versus State of Karnataka, and also in Welfare Association ARP versus Ranjit Goyali in 2003. And now we'll go to another declaration of the Supreme Court in the same leading case B.B. Sonathia and Company versus State of Karnataka, and that is even when Parliament makes a declaration under entry 52 of list 1 that the control of a particular industry by the union is expedient in the public interest, the state legislature shall retain its power to legislate in regard to the raw materials used in that industry. And now we'll go to another important pronouncement made by Supreme Court in 1991 in the leading case Odisha Cement Limited versus State of Odisha. So where it was pronounced that even when Parliament legislates under entry 7 or 52 of list 1, the exclusion of the state legislature is not total. It would be confined only to those aspects of the industry which are brought under the control of the union by the relevant legislation, as it was pronounced by the apex court in this important leading case, Odisha Cement Limited versus State of Odisha in 1991. And now we'll discuss about the ruling of Patna High Court in 1991 in the leading case Mahavir Prasad Jain versus State of Bihar, where it was pronounced by the Patna High Court that when one entry is made subject to another entry, it means that out of the scope of the former entry, a field of legislation covered by the latter entry has been resolved to be specially dealt with by the appropriate legislation. And now we'll discuss the ruling of Punjab and Haryana High Court in the leading case Indian Oil Corporation versus Municipal Corporation of Jalandhar, where the Punjab and Haryana High Court pronounced that state legislature cannot levy taxes on the entry of goods into local area which are not meant for consumption, use, or sale therein. If in the exercise of its authority the state legislature uses wide words, such words are construed in such a manner that it is held that the state legislature had intended to restrict those words and phrases in their meaning within the parameters of the competence of the state legislature. The state legislature cannot empower municipal committees to levy tax only on the entry of goods within the local areas when those goods are not meant for consumption, sale, or use within that area, as it was pronounced by the Punjab and Haryana High Court in this important leading case, Indian Oil Corporation versus Municipal Corporation of Jalandhar. And now we'll go to another important ruling made by the Bombay High Court in 1990 in the leading case Bhanu Shankar Bhatt versus Kamal Tara Builders. So, where it was pronounced by the Bombay High Court that entries in the legislative list had to be construed according to Pith and substance. The Bombay Money Lenders Act 1946 is enacted under the state list entry 30 relating to money lending and money lenders relief of agricultural indebtedness. It does not fall within union list entry 46 which deals with bills of exchange etc. as it was pronounced by the Bombay High Court in this important leading case Bhanu Shankar Bhatt versus Kamal Tara Builders in 1990. And now we'll discuss another important pronouncement of the Supreme Court in 1989 in the important leading case Ujagar Prints versus Union of India. So, where the Supreme Court pronounced that entries in the legislative list, it may be recalled, are not sources of the legislative power, but are merely topics or fields or legislation and must receive a liberal construction inspired by a broad and generous spirit and not in a narrow pedantic sense. The expression with respect to Article 246 brings in the doctrine of Pith and substance in the understanding of the exertion of the legislative power, and wherever the question of legislative competence is raised, the test is whether the legislation looked at as a whole is substantially with respect to the particular topic of legislation. If the legislation has a substantial and not merely a remote connection with the entry, the matter may well be taken to be legislation on the topic. So, this is one important pronouncement of the Supreme Court on the very doctrine of Pith and substance. In this important leading case, Ujagar Prints versus Union of India. And now we'll discuss another important ruling made by the Supreme Court in connection to all Kerala online Lottery Dealers Association versus State of Kerala in 2016, the Supreme Court pronounced that Article 246, Clause 1 of the Constitution of India deals with exclusive power of the Parliament to make laws with respect to matters enumerated in List 1, which is Union List, in the Seventh Schedule, as per Article 246, Clause 2. Parliament and the legislature of any state also have power to make laws with respect to any of the matters enumerated in list 3, which is concurrent list in the seventh schedule. The legislature of the state has, however, exclusive power to make laws with respect to matters enumerated in list 2, which is state list, in the seventh schedule. As per Article 246, Clause 3 of the Constitution. Also, there being a specific entry dealing with lotteries, the power to legislate on lotteries would be in the exclusive domain of the Parliament, even though it is a form of gambling and would be generally covered under item number 34 of list 2, which is the state list under the seventh schedule of the Constitution. So, this is one of the most important pronouncements of the Supreme Court made on the very doctrine of Pith and substance in this important leading case. All Kerala Online Lottery Dealers Association versus State of Kerala. And now we will go to another important ruling of Supreme Court in 2015 in the leading case Madras Bar Association versus Union of India. So, in that connection, the Supreme Court pronounced that it is impermissible to legislate in a manner as would violate the basic structure of the Constitution. It has been authoritatively held that an amendment to the provisions of the Constitution would not be sustainable if it violated the basic structure of the Constitution, even though the amendment had been carried out by following the procedure contemplated under Part 11 of the Constitution. The same would apply to all other legislations as well, even though the legislation had been enacted by following the prescribed procedure. So, this is also another important pronouncement of the apex court in this important leading case, Madras Bar Association versus Union of India. And now we'll discuss another important ruling of Supreme Court in 1995 in the leading case, University of Delhi versus Raj Singh. So, in that particular ruling, it was decided by the Supreme Court in relation to the doctrine of Pith and substance, where it was held that considering Union List Entry 66, Supreme Court has held that University Grants Commission has jurisdiction to coordinate and maintain standards of higher education. The regulation of 1991 made under Section 26 of University Grants Commission Act 1956 regarding qualifications for teachers was held to be valid. In this important pronouncement by the Supreme Court, In the leading case, University of Delhi versus Raj Singh. And now we'll discuss another important ruling of the Supreme Court in 1990 relating to the leading case. Federation of Hotel and Restaurant versus Union of India, where it was pronounced by the apex court that it should be considered whether a fair reconciliation cannot be effected by giving to the language of the Union legislative list a meaning which, if less wide than it might in another context, bear, is yet one that can properly be given to it and equally giving to the language of the state legislative list a meaning which it can properly bear. And now we'll go to another important leading case, and the very pronouncement was made by the Bombay High Court in this important leading case, Hanuman Vitamins Foods Private Limited versus State of Maharashtra, where it was pronounced that Article 25, Clause B of the Bombay Stamps Act 1958, as amended in 1985, which levies stamp duty on documents of transfer of shares in cooperative societies, falls within concurrent list entry 44, which deals with stamp duties but not including rates of stamp duty, and state list entry 63, which reads with rates of stamp duty in respect of document other than those specified in the provision of list 1 with regards to rates of stamp duty. It is therefore within the competence of the state legislature. In any case, the Act has received the assent of President of India, and its validity cannot be questioned, as it was pronounced by the Bombay High Court in this important leading case, Hanuman Vitamins Foods Private Limited versus State of Maharashtra in 1990. And now we'll discuss another important pronouncement of the Supreme Court in 2013 in the leading case, Lily Thomas versus Union of India, where Supreme Court pronounced that the legislative power of Parliament to enact any law relating to disqualification for membership of either House of Parliament or Legislative Assembly or Legislative Council of the state can be located only in Articles 102, Clause 1 and Article 191, Clause 1 of the Constitution, and not in Article 246 of the Constitution, as it was pronounced by the Supreme Court in this important leading case, Lily Thomas versus Union of India in 2013. And now we'll discuss another important pronouncement made by the Supreme Court in 1994 in the leading case, Attorney General of India versus Amrit Lal Prajimban Das. So, where Supreme Court pronounced that with reference to legislative entries relating to preventive detention, which falls under Union List Entry 9 and Concurrent List 1 Entry 3, the expression security of state and security of India are different expressions. It has been held that Parliament can enact legislation for preventive detention of smugglers, and accordingly, the Parliament of India enacted the Coffee Push Act, which deals with smuggling and for the forfeiture of assets obtained by smuggling, as it was a pronouncement made by the Supreme Court on the very doctrine of pith and substance in this important leading case. Attorney General of India versus Amrit Lal Pradambin Das. And now we'll go to the last important leading case dealing the very doctrine of pith and substance, which is derived from the very provisions of Article 246 of the Constitution, and the very important leading case is West Bengal State Cooperative Bank Limited versus State of West Bengal in 2013, and the very judgment was delivered by the Calcutta High Court. So, the very judgment as regarding the very doctrine of pith and substance, so whenever a bill passed by state legislature in respect of matter enumerated in the state list is kept reserved by the governor for the consideration of the president, such a bill necessarily assumes a distinct and special character, as it was pronounced by the Calcutta High Court in 2013 in this important leading case, West Bengal State Cooperative Bank Limited versus State of West Bengal. So, we have completed very important doctrine in constitutional law, and in particular in relating to the Constitution of India, and in substantially it involved the legislative power of the parliament and the legislative power of the state in regards to union list, state list, and concurrent list, which found place under Seventh Schedule of the Constitution, that we have completed in this lecture. And in our upcoming lecture, we will discuss about another important concept under constitutional law of India, and that is residuary powers of legislation.